The law, Aristotle remarked once, is reason unaffected by desire or free from passion. Either way, the conventional take on this Aristotelian wisdom has been to consider a discharge of judicial function to be invariably undertaken with dispassionate objectivity. Unsurprisingly, upon assumption of office a year ago, conventional wisdom dictated that the CJB's prime role would be to deal in legal abstractions and procedural intricacies with that all-pervasive sense of objective detachment. Not so. The convulsive reordering of the political economy of Bangladesh by the July Revolution had us all rethinking our priorities in general and our mode of justice delivery in particular, pretty much from the word go. It was evident from the outset that the reordering of the political order would have far-reaching consequences on judicial governance. This was brought home to me in the very heady days of August 2024, when my first reform intervention came in the area of legal aid. Distinguished guests, you see, legal aid as a conceptual construct is unavoidably an inextricable part of the justice delivery ecosystem. That means that it is organically linked to other stakeholder actions and therefore has to be responsive both to the strengths and weaknesses, for example, of police investigations, prosecutorial services, and judicial capacity, to name a few. Accordingly, and almost as a knee-jerk reaction to the real-time events unfolding in courtrooms across the country, the CJB's office extraordinarily, in cooperation with the NLASO, added a criterion to the availability of legal aid service via an official notification on 9th of September 2024. The problem thrown up, ladies and gentlemen, was particularly of individuals finding themselves in court without any legal representation, not because they could not afford to hire the services of a lawyer, but because they were prevented due to physical and other uniquely debilitating circumstantial constraints from accessing lawyers. The immediate response of the CJB's office was to add the capacity test to the pre-existing means test to make it easier to such individuals to claim legal aid. The said official notification of September 2024 clearly specifies thus. আমি বাংলায় পড়ছি, পরে আমি ইংরেজি অনুবাদটা আপনাদেরকে পড়ে শোনাবো। আইনের শাসন ও ন্যায় বিচার প্রতিষ্ঠা করার নিমিত্ত বাংলাদেশ সুপ্রিম কোর্টের হাইকোর্ট বিভাগের বিচার শাখা বিজ্ঞপ্তি নং 27/2024 যে তারিখ 25 অগস্ট 2024 মূলে আদালতে উপস্থিত আসামিদের আইনগত সহায়তা প্রদান নিশ্চিত করার লক্ষ্যে আদালতে উপস্থিত আসামিদের পক্ষে আইনজীবী নিযুক্ত না থাকলে লিগ্যাল এইডের আইনজীবী প্যানেল থেকে আইনজীবী নিয়োগ করার জন্য বাংলাদেশের মাননীয় প্রধান বিচারপতি মহোদয় নির্দেশনা প্রদান করেছেন। And the notification further reads, এমত অবস্থায় যদি কোনো আসামি উদ্ভূত বিশেষ কোনো পরিস্থিতির কারণে আইনজীবী নিযুক্ত করতে না পারেন, তাহলে তাকে অসমর্থ ব্যক্তি হিসেবে চিহ্নিত ক্রমে লিগ্যাল এইডের আইনজীবী প্যানেল থেকে আইনজীবী নিয়োগ করার মাধ্যমে আইনগত সহায়তা প্রদানের প্রয়োজনীয় ব্যবস্থা গ্রহণের জন্য নির্দেশক্রমে অনুরোধ করা হলো। Allow me to translate the text of that Bengali notification for better clarity. And the English text that has been translated by the Supreme Court Registry goes thus, and I quote, "For ensuring rule of law and securing justice, pursuant to notification number so-and-so, dated such and such, dated 25th of August 2024, of the High Court Division Judicial Section of the Supreme Court of Bangladesh, the Chief Justice of Bangladesh has directed that in order to ensure legal assistance to accused persons present before the court, if they are not represented by a lawyer, an advocate shall be appointed from the legal aid panel to represent them." The notification further directed that, and I quote again, "In such circumstances, if any accused person is unable to appoint a lawyer due to any special situation, he or she shall be identified as an incapable person, and necessary measures shall be taken to provide legal assistance to him or her by appointing a lawyer from the legal aid panel as per direction." End quote. Distinguished guests, there was a dual purpose to be served by this amendment, i.e., empowering a citizen to readily access legal aid under the most egregiously aggravated circumstances, and for the court itself to call for legal aid intervention readily in appropriate situations. 1 year into my administration as the Chief Justice of Bangladesh, ladies and gentlemen, there has been a seismic change in the very concept of justice delivery, justice administration, and judicial reform. Quite undeterred by the Aristotelian prescript that I quoted above, the judiciary has been infused with the passion to transform. This has also informed our concept of the administration of legal aid and the need to constantly evaluate its scope and nature. As we move on, the call is for legal aid administration to be preemptive in complexion with capacity to anticipate change. As I've already stated earlier, the legal aid regime is organically linked to other stakeholders in the justice delivery ecosystem. The past 1 year has taught us that conceptual and systemic changes in case filings, criminal investigations, quality of prosecutorial and government pleader services, in that these have to be brought at par or up to par with other far-reaching reforms already introduced in the justice sector. I'm happy to say that my office has had a head start in this regard in engaging in the process of ultimately establishing, for example, a professional prosecution service, and hopes for the reform agenda in that regard to pick up steam duly. The clarion call here is for all stakeholders in justice delivery to create strategic partnerships, to shape the kind of justice value we want for this country looking ahead. This, we now fully appreciate, can be best achieved by a rethinking of our respective roles, free from undue constrictions of any kind. This collective endeavor shall bring in the paradigm shift, the indications of which are already to be witnessed out there, and as has been laid out before you today, from a court-centric to a people-centric system that protects citizens from undue and egregious encroachments into their rights and entitlements. Legal aid services, ladies and gentlemen, are central to our reform discourse, aiming at the reinvention and reorientation of a once sluggish, top-down system to a service-centric one committed to provide quality adjudication, comprehensive services, and expanded diversionary alternatives to adversarial trial. The result should be a reinvented governance regime driven by the motto that people in plight and distress deserve and expect an expeditious and effective disposal of problems. Happily, the Legal Aid Amendment Ordinance of 2025 goes a long way in that direction. The 2025 Amendment Ordinance reminds us that ADR and legal aid are not marginal concerns. They are the very bridge between the formal justice system and the people's lived reality. It is here that the poor woman fighting for maintenance, the migrant worker cheated of his wages, or the farmer displaced from his land first encounter the law in action. If that encounter is humane, swift, and inexpensive, then the law has meaning, and the justice delivery system has relevance. If it is delayed, costly, and alien, then the law is discredited, as is the system. This is why ADR and legal aid must be the vanguard of judicial reform. Ladies and gentlemen, the student-led revolution of July 2024 taught us that legitimacy does not flow from decree or position, it flows from trust. The judiciary as a whole will command trust only if it is seen as independent, efficient, and compassionate. Independence means a judiciary free from executive interference, with its own autonomy to manage its budget and administration. Efficiency means modern procedures, digital platforms, and ADR mechanisms that reduce delay and backlog. Compassion means legal aid that is not perfunctory but transformative. These are not abstract ideals. Rather, they are concrete reforms now underway even as we speak. And this conference is an opportunity to evaluate our progress and chart the way forward. To conclude, ladies and gentlemen, the judiciary, as a fully functioning constitutional organ of the state, will continue, and indeed must continue, to stand shoulder to shoulder with all relevant stakeholders in this journey, confident that the reforms of today will be the legacy of tomorrow. Thank you very much.